when I did work as a contract specialist, so I've worn many hats. I don't even know how I've done it. Is that some of the aspects that we dealt with there was to assess the supplier's compliance with the law. So you look at are they complying with sanctions law? When I talk about sanctions law, is to say that are they contracting with other businesses, for instance, that are sanctioned? When you look at human resources, we've looked at how are their labor practices. When you look at E and BE, are they complying? Yes, we've seen the certificate, but what is the make-up and who will be doing the actual work? So those are the things that I'll be dealing with there because these are quite important. A lot of the times, obviously, they are not done as extensively because of some of the challenges that procurement officers face in terms of the volumes of work that they need to do. But I like that concept of having dedicated legal teams that come in and do that particular assessment. So as an example, when I was in procurement, I was working closely with the legal team because I had a legal background. So that's easy for me to rope in legal minds to assist with that particular process and then leave the commercial side of things to the procurement team. But this is something that I'll definitely extensively discuss in this particular session. So thanks for laying the land for me in that regard. So obviously, as I was saying earlier on, was about a particular bold decision that was taken by the organ of state in this regard. And I say bold decision, not because other entities don't want to do it, but because based on a risk assessment that you'd get from a risk team, for instance, you may shy away from taking such a bold decision. So you will have examples but in terms of court cases, a disqualification based on a due diligence of this kind, for instance, where the facts are of this particular nature, is not something that you see on a day-to-day basis. So I talk about it as being a bold decision. And let me explain why. So in this particular case, we had a bidder, obviously, I think as part of a joint venture, that submitted a bid in this particular matter. And during the bid evaluation stage, right, it came to the attention of the committee, of course, that one of the parties in this particular joint venture, as an example, had been investigated by the SIU in a tender in Limpopo. Right. And the SIU had found that there was some wrongdoing, unlawful activity in that regard, and had taken the case to the SIU tribunal. Right. So for those who may not be aware, when a proclamation is given by the president to investigate a particular organ of state for any form of corruption or malfeasance, right, the SIU then does an investigation, makes its finding, and then obviously when they find that there's wrongdoing, they then take that matter to the tribunal for the tribunal to then make a determination on what consequences should be meted out on a particular entity, as an example. So in this regard, this is what happened in this regard. So this was all happening, unfortunately for the bidder, but fortunately for the organ of state, that all this was happening at this particular same time when this bid was being evaluated on a completely different tender, by the way. So let's be clear, it was on a completely different tender, but the Limpopo tender was the one that was under investigation in that regard. During this time, right, the National Treasury obviously was made aware, because obviously one of the things that SIU must do is that if there's a bidder that has been found to be involved in any unlawful activities, National Treasury must be informed, because National Treasury has got a list that I think we debated about 2-3 years ago in this particular session of those entities that are found to have, acted in an unlawful manner and therefore are restricted. So you have this restricted list or a list of tender defaulters in that regard. During this time, and I'm giving you this background so at least you understand where I'm going with this. During this time, one of those entities that was obviously found to have been guilty of this unlawful activity then approached the SIU tribunal for a legal settlement. So obviously for the lawyers in the room, you will understand, obviously settlement usually comes in by saying, I'm not acknowledging that I did anything wrong. I'm not acknowledging that I did anything wrong, but I'm going to pay the fine. I'm using an example here. But you can't say I did anything wrong, but I'm paying this fine. In this case, goes away. And I think it's similar to what we saw with the NPA and the ABB matter, where, for instance, with regards to, I think, Transnet, if I remember correctly, in that regard, there was some wrongdoing that the service provider had. And instead of going through a process of going to court and being found criminally liable as a company, because you can't find a company criminally liable, they then decided to have a voluntary settlement and pay a particular amount of money. So this is what happened here. That's what happened here, a settlement. So SIU said, okay, give us the money. You can go away. No further action will be taken by us. And at the same time, I think Treasury then, after getting some of the review documents, so let's just remove this particular entity from the restricted list in that regard. But the evaluation committee said, you know what? This company has been found to have acted in an unlawful manner in a tender. And that type of risk for us is a bit too much from a legal perspective, right? Because we might find ourselves perhaps one day being roped into a legal battle because obviously they are supplying us and we get roped into that. Two, there's a reputational risk in that regard. Therefore, we're disqualifying you on the basis that you were found to have acted in an unlawful manner. But obviously the defense here was like, no, but we settled. And the court said in this regard, and I want us to be very clear, the court said the settlement was not an acknowledgement of guilt. So they did not raise any defense on whether or not they acted unlawfully. So ordinarily, if you are accused of something, the best course is to say, no, I did not do it, and here's the proof. And we test that. In this particular matter, no proof was raised to the contrary. Therefore, that stench of unlawfulness remained until such time that they can prove that they did not act in an unlawful manner. So the court said, on that basis, the evaluation committee was right to disqualify you on that basis after doing their own due diligence in that regard. So obviously, I say this is a bold decision because it could have gone wrong. It could have got to a point where, for instance, the court said, hey, this guy settled, their slate is wiped clean, therefore it was unfair for you to keep punishing them again. But I think what is important here, and that's why when you do a due diligence, you must be very clear, one, on why you're doing a due diligence, and two, what the consequences of that due diligence are, but three, you give the other party an opportunity to raise a defense, for instance, and if you've done an assessment, you say, okay, no, this risk does not link to what we're trying to achieve here, then you can go ahead. But in this instance, the other party was not interested in showing that they had not acted in an unlawful manner. So this became a very bold decision, and they got it right. Right? They got it right. And that is what happens when you've got very robust due diligence processes. And when I talk about due diligence, I talk about due diligence by design. Because if it's due diligence by default, where you're just looking at rules and saying, hey, I've ticked a box as some of you have raised earlier on, then it becomes problematic. But if it's part of your design and you've got robust systems that can be tested at any point, this is what the result is. So for me, this is a victory for organs of state. Because one of the things I've always lamented, and Sean knows this very well, is how sometimes organs of state have been unfairly lambasted by courts for trying to get over the line in the most practical manner. So this is a victory for public procurement practitioners. And I think the second part of this court case is something that you must read as much as you can and build your processes in that regard and build robust systems in that regard. But always remember that just make sure that you understand what the legalities are around this thing. And with this one, there was an unlawful act. And till this day, by the way, there's been no contrary view from that particular bidder on whether or not they were guilty or not. So they signed it to make this matter go away, but unfortunately, they are now caught in this particular situation. So in future, if they want to tender for a next bid, they need to make sure that they're able to answer these questions, because remember, at the end of the tender document, or most of the time, there is a declaration that must be made. In that declaration, this particular bidder moving forward needs to make sure that they're able to answer some of the questions and concerns that an organ of state may have, because due diligence will be done. So that's the background that I want to give, and I've spent a little bit of time in that regard, so that at least there's an understanding. So I know this looks very text heavy. Don't worry, I will not be reading. I'm not known for reading off the slides, but I did this because obviously these slides will be shared. And I want you to at least have a full understanding, even when I'm not in the room, to say, oh, this is the full context of what was meant in that regard. So, due diligence by design and its challenges. So, I've been very open and honest and clear for many, many years now about how I empathize with the plight of procurement practitioners, right? And this is an appreciation that I had once I worked within procurement for a couple of years and realized that sometimes when the legislature put in place certain rules, they did not anticipate the practical effect thereof. And that's why the Public Procurement Act became a very important platform for many of us on this call to raise some of our concerns. And yes, not all of them were adequately answered, and we're hoping that the regulations will then answer them. But obviously, those challenges still remain. So when you do due diligence, right, and this is something that I think Sean spoke about when this case first came about how do due diligence throughout the entire process. So when it comes to procurement, I always talk about the 4 Ps. So those who've been in my presentation will always know I always talk about the 4 Ps. And I got these 4 Ps from an individual who is raising his hand now, but don't worry, I'll take your hands later when I'm done. That's so there. I saw your hand coming up. So I took the 4 Ps from him. So I'm happy that he's in the room so that he can make sure that I've not put shame to the 4 Ps. So the 4 Ps are planning, right? Do you do due diligence during the planning phase? I'll answer that later. Secondly, during the actual procurement process when you're evaluating, do you do due diligence there? That speaks to Sean's point about it may be a waste of time to do extensive due diligence on everybody. 3, the post-procurement phase, that's the 3rd P. Do you do your due diligence when you're now contracting? That speaks to what Gloria was raising. So you see, I'm raising you by name now to show you that all the things that you've raised here are quite relevant. Or 4, do you do your due diligence during the performance stage? When you've now awarded and now this particular bidder is now a supplier and given this particular aspect, right? So these are some of the things that I'll, at the end of this particular presentation, I hope I would have answered, but there's just 6 things that I want to quickly get through, so at least we can then also get into the meaty part of questions, because I enjoy the questions. So we'll have perhaps the last 30 minutes for that. So when you do due diligence, right, you are trying to obtain as much information as possible with regards to a particular process in that particular regard. So you don't only rely on the information that the supplier gave you or the bidder gave you. You also need to, also when you get that particular information from a supplier, you need to be able to assess, as Gloria spoke about earlier on, to say you need to have a team that can sit there and say, yes, you've submitted this tax clearance certificate, but what does it mean? Why did I ask for this tax clearance certificate in the first place? You know, those type of things. I asked for a B certificate. Okay, what does it mean? Right. So one of the main things is to say, at a point when you go out on tender, you may not have a full appreciation of all the information that you require. And that's why earlier on, before the session started, we were talking about expression of interest, where some entities have realized this and they go out to the market and seek an expression of interest, because that is a way to mine information in that regard. But off the bat, 180-day tender that is out there, you find that as procurement teams, when you're trying to do your due diligence, you have limited access to information. Right. And when you speak about that tier 1, so I don't know if any of you know about the new beneficial ownership rules that have come about with the grey listing of the country, and how the Companies Act, for instance, has put in place beneficial ownership reporting requirements in that regard. And this is a question I asked at a session that we had in Pretoria last year, at one of the procurement sessions that we had. Should a procurement practitioner worry about the beneficial ownership information of a bidder? What will the beneficial ownership information for bidder help you with? 3, do you need to know the beneficial ownership of all the 1,800 bidders in that regard? So if you then do due diligence by design, these are the questions that you must already have and put in place a system that is not tedious, a system that is practical, but a system that answers the why. Why? At the end of the day, why am I doing this? What do I seek to achieve, right? The second thing, and this is something that used to frustrate me a lot when I was in procurement, is inaccurate information submitted by the bidders themselves. So you say to the bidder, I want your annual financial statements of the last 12 or 24 months. And then they give you financial statements from 24 months ago. 48 months ago. There's a reason why you are asking for this financial statement. You wanted to understand the financial health because what we've seen, and many of you will know this, we've had bidders who have submitted a bid and have got no money in the bank. And what they are relying on is that if they are successful, they'll get a prepayment. And I think, Sean, I think there was a session many years ago where we spoke about prepayments and the risks and dangers of prepayments. And I remember in one of the sessions, I gave an example of a particular municipality after a strike. The community wanted a road, and the mayor went out on tender, obviously through the procurement process, and the bidder charged 50 million, and they gave the bidder 50 million in advance. And the bidder ran away with the money and liquidated. A year later, Mayor had forgot about that. They went out on tender again. This time it was 60 million. Again, there was a prepayment of 50 million. So, but obviously that's a different presentation that we did many years ago. But I like to give that example because it's actually a real example, by the way. But I won't mention which municipality that was, just in case one of you is from the municipality and then you now go and do a PIA application in that regard. Right? But inaccurate and incomplete data is something that is hamstringing procurement teams as we speak now. And this is more so because you have asked for accurate and you have asked for complete data. This then becomes a challenge for you to be able to do proper due diligence in that regard. But let's say they give you everything that you require, but how many of you can relate to bidders that throw papers at you? Well, what I mean by that is they give you more than you asked for. And what you asked for is lost in the detail, and you must now skim through that particular thing. So obviously, these are some of the challenges that you need to think about in terms of that data overload. But another thing is, how do you verify that this information is correct? So Gloria spoke about legal compliance. Here's a certificate there. How do you verify the validity of that particular compliance document? Do you have time before the bid validity period expires? Do you have time to actually do all these verifications? Or it's a trust system to say, no, they declare that the information is correct and therefore we move on. But obviously we've known that in many instances, even this Aventino case, there were certain bidders that made some misrepresentations in the documents that they made. This puts more strain on the particular system because obviously you've got time pressure constraints, you've got budgetary limitations, and sometimes you've got lack of expertise. So if we took that particular legal compliance aspect and we only had the procuring business and the procurement team, and there are certain aspects that go beyond procurement law that needed to be assessed, you may not have the necessary expertise. And that's why sometimes it's always critical to also have what you call a bid specification committee. And I think some of the entities now have bid specification committees because that's where you start looking for expertise before you even go into evaluation. It's at the spec level, right? So another thing is that obviously there's a lot of personnel shortages. I always worry when an entity that knows that they rely a lot on outsourcing does not invest in their procurement team. Some have claimed this deliberately. Some have claimed it's just negligence in that regard, but you need to have your procurement team sufficiently staffed and staffed with the necessary expertise and experience to be able to deal with some of these issues that I speak about there as well. With due diligence as well, and the information overload that I spoke about, Having manual processes is becoming more and more challenging, right? And I know a lot of us still use Excel because that's what we have. That's what the organ of state has, right? But so if I start talking about data analytics, if I start talking about Power BI, if I start talking about AI, then I've lost a lot of people, not because they don't know about AI, but it's because they can't relate because their organization does not have processes in place for automation. So the manual processes do make it difficult to make sure that there is proper uh, verification and due diligence that is done, because also, you want to make sure that you've got all this information and you can consume it as quickly as possible so that you can be able to move ahead in that regard. But also, when I spoke about having a robust SCM process and a robust SCM system and a robust SCM policy that is quite clear in terms of what you need to do, there's a lack of standardization. So a lot of the times, one, there is no due diligence process at all. Even the risk team in your organization that's supposed to help you with this due diligence doesn't have processes in place. Or B, you do it in a haphazard manner, not because you want to make it haphazard, but because there's no robust conversation about how to standardize this particular due diligence, but also you're doing due diligence by default. You're looking at the law and then doing a tick box exercise. Whereas if you do it by design, you embed this into your systems. But it doesn't mean you need to evaluate all 1,800 bids in terms of that particular due diligence. When we speak to the next one, which speaks to supplier related complexities. So a lot of you have spoken about the supply chain issues. And one of the things that I was involved in last year, for my sins, I was part of the B20. All right. So B20 is the business leg of the G20. And we had to discuss a lot of compliance issues with countries from around the globe. And then you see that in China, things are dealt with differently from America, different from EU, different from Africa, and all those things. So when you're doing a due diligence, especially for those who want to contract with OEMs, which is your original equipment manufacturers, you find that with OEMs, you don't sometimes deal with a company that's sitting in South Africa. You have to deal with the company that's sitting in the EU. Or B, if there's an OEM, but the bidder is the one that's submitted and it's a local one, those third-party risks that Gloria spoke about need to then be assessed. That to say, with my due diligence, and this happened, I think, 2 weeks ago in another matter that I was advising on, where, for instance, the bidder submitted a bid on the strength that they would get these goods from an OEM sitting in Asia, right? And then during the first 100 days of the Trump presidency, tariffs became a concern, and that OEM said, hey, I want to focus on local supplies, so I'm not going to be exporting any of my goods and services. And you would say, hey, how does that link? But these are some of the questions that businesses have to deal with. So now what this bidder was saying was to say, thank you for giving me this particular award. However, I no longer have an OEM. Therefore, I'm going to source second-hand goods locally. Right. So a due diligence aspect is something that must be able to try and proactively anticipate these issues. But two, during the due diligence at planning stage, did you foresee that second-hand goods would have to be used, and are second-hand goods going to be sufficient for you to deliver on your service delivery aspects in that regard? The last one I want to speak about on this one is supplier resistance. And when Sean spoke about, I used to work in one of the big four audit firms. I remember we used to resist a lot in terms of companies that wanted to do information technology audits on us as a supplier. So off the bat, that sounds like, but no, why don't you want your client to make sure that you've got robust IT systems? Because remember, that's what you call an IT audit, right? And it's a contractual principle, by the way. And maybe one day I'll do a session on IT audits and the risks involved, right? The problem with doing a IT audit is that you go into a supplier's system and there's no way of segregating information. So remember, when you're doing a due diligence, you're trying to see how the company works and the like. So you can't segregate information. And then you end up having access to the IT systems, and ultimately you could even end up hurting the integrity of the information that is lying there. That becomes a papaya consideration. So sometimes you will get supplier resistance. So that's why you need to make sure that when you ask for an IT audit, due diligence, for instance, on your supplier, because now let's say they've now been appointed and the like, but you're still doing your due diligence. Why do you want to go into their systems? Why do you want to know the full extent of their systems? But also remember, you might then stumble upon information that is sensitive of a third party. That has got nothing to do with you, because remember, the suppliers opened their systems to you. So always ensure that when you do a due diligence, you can answer the why. Why do I need this information? How this information pushed the needle? And this links back to the Aventino case in the sense that the bid evaluation committee said, why do we care that they were found to have acted unlawfully and have settled and they've moved on? Why? Because we don't want to be dealing with an entity that is not willing to be honest about whether or not they're unlawful or not. All right. So that why must be something that you must always have at the back of your mind. And that's why you must have or build risk assessment and risk management systems within procurement, right? So one of the things that I've been spending a lot of time on this year specifically is helping businesses build risk assessment and risk management processes in that regard, because it becomes quite critical for you to make sure that you've got a risk-based approach in your procurement system, all right? You need to be able to anticipate what the risks are proactively, but B, if you don't pick up a particular risk, how do you react to it reactively? Because you will always have a reactive risk assessment and you will always have a proactive risk assessment in that regard. So this is where I want to end it off with these blocks. And I've put color to it so that at least it doesn't look like the other text-heavy things that I said I've just given you for your leisurely reading. But these blocks, I want them to come alive for you and for us to just spend the last 15 minutes before we go into questions, of course, on this particular aspect. And this is based on the Aventino case coming out and the debates that I've had with various individuals, including Sean yourself, with regards to this due diligence by design. So I've spoken at length about the challenges, but what's the solution? How do we become like this organ of state that dare to go against a service provider and say, because of my due diligence, this is my outcome, and I stand with it, and I'll go to court with you, and I'll win, and they won. All right. So, first question. Do you do due diligence at the planning stage? All right. So when you're sitting as a bid specification committee, for instance, or when the procuring unit decides, you know what, in the next year or so, we need to buy software. I don't know what type of software yet, but we need software, right? At that stage, can you do due diligence? Do you have time to do due diligence? So one of the things that I always advise procurement teams is that during the planning stage, when you're doing your market analysis and market research, and I know a lot of you here, because some of you are even members of SIPs, you want to do these types of market research. So you have to do your homework in that regard. So you need to do an industry-wide or sector-wide due diligence. Look at the competitive landscape. Look at the regulatory landscape. So an easy example that I always use is the procurement of software. When you do your due diligence in the software industry, one, you look at, do you have local suppliers? Because remember, when you've got local, it affects price because it may be cheaper. I'm not saying it's guaranteed to be cheaper, but it may be cheaper. Secondly, what is the track record of these local companies? Right. Or secondly, do we only have OEMs who are sitting outside the country? What is the track record? How have they competed in the market? And secondly, what are the regulatory issues that one needs to think about? This is where you can then rope in your legal team, because you don't have to do all these things of due diligence alone. So due diligence must be done by procurement, the procuring unit, by risk, by legal, by finance. All these teams, cross-functional teams, must come together. Please don't allow your organizations to push this responsibility on you alone. You can lead it, but you won't have all the answers on your own. So please make sure, that's the advice I give you, because many times I've seen a lot of entities pushing this to the procurement team alone, and the procurement team buckles under pressure and certain things fall through the cracks, not because they were negligent, but because they were being given responsibilities that were beyond what they're supposed to be doing. We've got experts sitting within the particular organ of state in that regard. So the regulatory landscape, if you use IT, for instance, look at, are there rules or are there laws that limit you from procuring particular software from a cybersecurity perspective, from a national security perspective, from a foreign entity, for instance, as an example? That's your due diligence, because you don't want to end up having a situation whereby you have gone through a whole evaluation, you have submitted this award letter, they've signed the award letter, now they want to start working, but there are regulatory blocks, and now you've wasted time. And as you said earlier on, we need to understand the cost of bid, but also the problem with regards to one of these things that you're dealing with in that regard. There we go. Right. The second thing is, do you do it when you receive the bids? Do you do it when you receive bids? All right. And it goes back to that example of the 1,800 bids. Do you want to do a financial health due diligence on 1,800 bids? Or do you want to go through the evaluation, right? And then perhaps maybe your top two, this is a random number, by the way, this is up to you because I'm not being prescriptive today. Maybe you say the top 3 bidders, or the top 2 bidders, or the winning bidder. I now want to do a financial health due diligence on you. Do you have funds? Can you deliver for the year without us paying you? Right? And when I say not paying you, not because you don't want to pay them, but because of how the payment structure is, as an example. But the second one is quite important, reputational. Reputational due diligence is quite key. And you remember, and I can name, I don't like naming local companies because obviously for various reasons, as a lawyer, I must always think about that. But I think we can use the EOH example here because EOH no longer exists. It's got a new name for those who don't know. So if I say EOH doesn't exist in my books, you can't go to CIPC and see EOH. It's gone. It's got a new name now, right? So with EOH, a lot of entities, if you remember, National Treasury being one of them, said there's a reputational risk in being associated with you. And we've done our due diligence, therefore, goodbye. And other entities did the same thing. And obviously, EOH went around, and I remember they went through a media blitz to try and say, no, it was us as EOH, but we've removed those people. It's no longer, those people no longer work for us, and we're trying to turn over a new slate. And I think they even went to the Zondo Commission and self-declared all the wrongdoing that the entity had done. So in that regard, your due diligence must then decide to say, do you want to do a reputational assessment for all 1,800? No, not necessary. But perhaps when you've got to a stage where you've got your top 2, top 3, just get a sense on whether or not they can perform, you can then embed that due diligence in that regard. And this is where, for instance, the bid evaluation committee did it. They had a smaller number, of course, of bidders. So they did their due diligence in terms of the legal due diligence, financial due diligence, and reputational. And they came out saying, nope, from a reputational perspective, we don't associate with this company, but also from a legal perspective, they have not denied any wrongdoing. And the next part, do you do it during contracting? So let's say you've awarded the tender. And I hope most of your bid documents have got suspensive conditions that says even though you're awarded, it's subject to a successful contracting process. Please do not say automatically when I've awarded you, you're automatically a supplier, because you don't know what might happen post-award. So please make sure your risk assessment or your processes have that in mind. We have seen instances where a bid has been awarded, something has come up, and you need to move. And I think one of the examples that we can use is with the licensing machine, where the Department of Transport, I think, has taken itself to court because there was an AG finding about the process to award to a particular bidder. And therefore now, do we continue with the bidder because you didn't have that escape clause? Or do you then go to court in terms of a self-review, in terms of the Buffalo case and all these cases, which I don't fully agree with, but that's a debate for another day. Sean, don't call me for that because I'll be criticizing court cases and I still remain a lawyer. I don't want to be seen as that guy, except if I made a bribe. Right. So at the contracting stage, already, Gloria spoke about we need to make sure that this particular supplier, once they are appointed, abides by BEEE, human resources, practices, sanctions, laws, all those things that I'd spoken about earlier on when we opened this particular thing. So these are things that you can already embed in the contract to say this due diligence becomes automatic by the fact that you are signing this contract and accepting that at this particular point in time, you're declaring that you're above board legally, you're above board operationally, and you're above board from a reputational perspective. Obviously, reputational is one that is quite loose. So you can't just say, no, I don't like how your media ad is different, therefore I'm no longer going to be associated with you. It must be something that is substantial, which affects the execution of a particular contract, right? That's how to do with the contracting stage. And then obviously, the last one there is the one that I spoke about, performance, right? Do procurement teams or supply chain management teams play a role during the performance of a contract? So you helped with planning for the procurement, you help with the procurement stage, you help with the contracting. Does your job end there? Do you walk away into the sunset and say, our job is done, on to the next procurement? Or do you play an integral role during the performance stage in that regard? And the answer for most times is yes. Because remember, you've got all the data of all the suppliers. You get reports from the procuring unit on how this particular entity is performing. So you, as a procurement practitioner and the legal team, are always informed. Why? Because if, for instance, two divisions in an organization are using one supplier and something goes wrong on the one side, but the other division doesn't know, and they continue with that particular service, you might find yourself in a risky situation to say, but why did you say there's a reputational risk with this particular contract, but the very same entity on this side, you're still continuing with me? So the repository for that information lies with supply chain or procurement, and therefore you must always ensure that you assist the legal team and the procuring team with regards to this particular type of due diligence. And that's why that last block is quite important, is that who should do it. And I say due diligence must be done by the procuring unit, must be done by procurement, must be done by legal, and I think I forgot to say must be done by risk as well. But there are certain entities that also want to do it independently so that they can have someone from the outside looking in as a consultant, as an example, to assess this particular aspect, but also because that independent entity might have the necessary due diligence skills and have access to the Competition Commission documents, for instance, and can always be able to assist with regards to having an extensive due diligence, which opens up space for you in that regard. So this is how I've linked the Aventino case and expanded it to make sure that your mind goes beyond looking at due diligence from a criminal liability perspective, looking at it from an unlawfulness perspective, but to say due diligence must go beyond that. But lastly, also to say that as much as there's so much pressure on the procurement team, as much as we've seen many cases going against organs of state, it's important to have those bold decisions. But those bold decisions must be backed by robust processes and systems. And one of the things that I like doing is building processes. Because once you build a process, you can plug in experts. And if ever anything goes wrong, you don't look at the expert first, look at the process first to see if the process was right. And if the process was right, then you can look at whether or not someone negligently then refused to follow the process. And remember, the process is what, for instance, Section 217 in my introduction speaks about, and it's what Section 38 of the PFMA also speaks about. So in that regard, I'll end it off here, and let's see if we can have some interesting questions, because I know there were already questions as I was presenting. Over to you, Sean.
Good one. Well done. Well done. Let's just quickly go to, now before I unmute the mics, Gaba Mabete, you know him well, Walter.
Yes.
I think before we allow him to ask his question, I think we should just wish him happy birthday.
Oh, yes.
If I'm not mistaken, I think it's your birthday today. Nabasa,
Yes.
welcome. Let's
Yes,
please
happy birthday.
go ahead and let's hear your point.
Thank you very much for the kind words, Mr. Sean Scott. I'm not going to accept the birthday wishes from the presenter. He was with me half of yesterday, and he sent me a message. I mean, I thought he would have started off with that to give himself some good runway for the lecture today. I will say, though, he did make a wonderful presentation, so I do appreciate that. Can we go back some 15, 20 minutes ago, please, Bhengu, when you mentioned that court matter with a settlement of the accused, for lack of a better term, who paid what ostensibly became a settlement. But subsequent to that, in the matter that was heard before the court, or the decision of the court that suggested that that was not exculpatory on their part, and that they would have to prove that their conduct was not unlawful. I want to probe that in the context of, please, the presumption of innocence, which is a constitutional prerogative in terms of Section 35 thereof. Had they actually been found to have acted unlawfully and so declared by a court, or was that the allegation on the other side made to them, subsequent to which they would have paid that money, which was which became ultimately the settlement, or did a court in that instance actually confirm and declare their conduct as such unlawful, and their payment subsequent to that would have been pursuant to what? Can you just clarify that? Because I'm of the view, absent a court declaring conduct unlawful, it isn't unlawful, absent it being proved as such. And that payment, whatever it was for, perhaps it doesn't exculpate them, but it certainly doesn't constitute an admission of guilt in any way. Am I making sense?
Yes, no, makes perfect sense. I've noted that.
Why not respond
Thank
to
you,
that?
Sean. Thank you very much
Okay,
indeed.
I can do that.
Yeah.
So no, thanks for the question, and it's a question. That's why I prefaced this particular part of the presentation on it being a bold decision. So, some 2 years back, I think it was the Supreme Court and the Constitutional Court in the Ledla judgment, right? So I don't know if any of you know about the Ledla judgment. It was speaking about the powers of the SIU tribunal. And funny enough, that particular judgment was hot on the heels of the same court having a similar or a different judgment on the competition tribunal and the powers of the competition tribunal. And I remember at that point in time, I was very scathing in my assessment of how the Ledla judgment elevated the status of the SIU tribunal to be equated to that of the High Court. I still hold that view that that was bad law, but I mean, until such time that someone else comes with another court case and the later judgment is withdrawn, you still have, for instance, the SIU tribunal, for instance, having a similar status as a high court, because remember, ultimately, the high court has those review powers that we always thought were the only powers that sit with the high court and not any other tribunal, and especially after the competition tribunal judgment that agreed with that. So with this, the reason I'm raising that judgment is that, remember, with this particular matter of the Limpopo tender, where this wrongdoing was found, right? So the SIU obviously found that there was wrongdoing. So obviously what happens here is that the SIU has got powers to make findings and make certain determinations to say, no, there was unlawfulness. But what they then do is they then go to the tribunal to then say, tribunal, please assist us with consequence management in terms of having this particular party then reimbursing the state for the benefit that they got from their unlawful act in that regard. So what would happen, obviously, with the settlement ordinarily, if you go back to a high court, right? You can have what you call an out-of-court settlement, or you can have a court-sanctioned settlement. And to make it more vivid for everyone in the room, the VAT case. I like to give things that are relatable so that I can link it back. So with the VAT case, the matter went to court, and there were two schools of thought. One school of thought say that no, there was an out-of-court settlement, and the other school of thought say no, there was a court settlement, where the parties did a draft settlement order, which was then stamped by the court and made an order of court. Whereas the out-of-settlement court means that you withdraw from the case completely and you go and debate it on your own and settle it. So what happened in this particular matter, Mr. Mapeka, was that it was a tribunal-sanctioned settlement in that regard, right? So in that instance, right, instead of saying, you know what, I'm like everyone else, I know there's a particular engineering company in Limpopo that has been fighting SIU for the last 15 to 20 years, where they're saying, I'm not going to acknowledge anything, I'm not going to pay anything, I'm innocent. Therefore, I want my day in court. With this particular matter, they said, you know what, we just want this matter to go away, we'll settle, we will not acknowledge that we did anything unlawful, but we'll pay the money anyway. So when you then link it back to the presumption of innocence and the fact that obviously only a court can make that particular declaration, in this particular matter, what has since happened is that this court has then now solidified the view of that particular segment to say there may have been unlawfulness and there's no contrary view. So whether or not, you know, that from a practical perspective, from a process perspective is the right way to do it, and whether or not there's a sense of double jeopardy here and the like is a debate that we can always have. But the court in this instance was saying, we still see the evidence that there was wrongdoing here. We don't see anything to the contrary. And therefore, with the powers that the tribunal has now, after the Dedler case as an example, this particular settlement is similar to a court settlement as opposed to an out-of-court settlement.
Can I just quickly engage that? Would the party who paid that settlement amount, were they invited to make representations before the court then came to the conclusion that the evidence before it that alleges unlawfulness is in fact unlawful? In other words, was that evidence tested by the party that was deemed to have acted unlawfully?
Yes, so remember here, there's three stages here. So the party was asked by one, the tribunal or SIU to bring in contrary evidence. They did not. Two, they were asked by the tribunal, did not. Three, were asked by the contracting authority, which is the organ of state, to say, bring us evidence to the contrary. They did not. And then fourthly, because now this has become a court case that involves them, they were again invited, remember, because when you're involved in a court case, you're invited to bring your side of the story in your defense. Again, they were given an opportunity at this final hurdle, in this particular Aventino case, to say, okay, here we are now. You've been disqualified on this basis. Give us evidence to the contrary, so that at least we can say, no, there was no wrongdoing. They did not take that opportunity as well. So they had 4 chances to actually put forward the evidence to the court. So the court was left with no choice but to say, I'm going to base my judgment based on what I have before me.
No, final contribution, and I'm sorry to belabor the point, but I'm just minded to then move to the Plascon-Evans rules that says a presiding officer can only come to a decision, and I know it's true for interdicts. I don't know if it is true for a decision in the general sense, that the evidence or the facts admitted by the respondent and submitted as their response to those submissions made by the applicant stroke plaintiff in the matter, only in those circumstances where those admitted facts by the respondent can a decision be made by the presiding officer that is supported by that. It would appear from what you have said that they were unable at least to come to that decision because there were no admitted facts from what you are saying by the respondent, in as much as they did not present evidence to prove to the contrary. So all the same, forget the engagements before the court process at that tribunal level and at contracting authority level. What was before the court? It sounds as though to me they couldn't have come to that conclusion because the evidence itself that makes the allegation of unlawfulness was not tested. And the fact that there wasn't another version doesn't destroy the obligation for the initiator of the litigation to prove his case.
Yeah, no, true. So with this one, definitely, it's one of those where we're saying we've brought our facts to the table as the organ of state. You need to come with your facts to dispute that in terms of that Plascon-Evans rule. Because remember, Plascon-Evans rules deals with that factual disputes, right? And then you decide not to bring any to the point. The court still needs to make a decision in that regard, and that's what the court did in this regard. Otherwise the court will be at ransom on someone who's refusing to answer.
Right, thank you.
All good on my side. Thanks for the indulgence, guys. Thanks, Sean.
Thank you very much. Thank you. Welcome, and have a good day. Let's jump to Khao, and then we'll go to Julia.
Yes.
Thanks again, Sean, and thanks, Mr. Bhengu. Interesting presentations, and I would just want to jump onto the previous speakers plus my events rule. Seeing that in because that case of Limpopo, I think our municipality in my province was the one who after due diligence did not appoint the service provider, the multi-equipment company.
Yes.
The issue here, which makes it even much more questionable in terms of the Plascon-Evans rule, is that National Treasury went on to enlist this company. And after the company queried the process, then National Treasury somersaulted.
Yes.
Which even gives more credence to the Plascon-Evans rule to say, before you hear the other side, you cannot take a decision. Now, here is the court that took a decision just because a person did not come and present themselves, even when invited. I'm not sure of the process of a National Treasury. But I think we've exhausted the Plascon-Evans rule, and I agree with the court in this instance, although these questions of the Plascon-Evans rule stays intact. For due diligence, it is this multi-equipment company, and the latest one is the one of the 2 million computers, the Bato Technologies, that happened during last week or the last week, yeah, the Mpumalanga case. My province has just taken a decision based on these two, just to notify the departments of these service providers. Remember, they're not enlisted in any restricted bidders yet, but we have taken the decision as a province to say, let's then inform our client departments as a PT to say, please take note. But we have shied away from saying, do not engage these companies. We just said, take note of their of the latest developments around these companies. Would we have been wrong had we said, please do not? Would it have been a much more heavier and directive instruction as we are empowered to do? Because look, in both cases, it's a big issue. It's big money is involved. Yes, yeah. For the Plascon-Evans rule, they have not been found to have defended themselves. But the issue is because I think in both cases, in the later one of the Bato Technologies, the company was found to have, and it did acknowledge that it misrepresented itself. Just on those, and then on the slide before this one, the one that you say is colorful, I only see black and white. So I don't know. I'll just please if you can just go one slide back. Yeah, the first one, where you say due diligence must be done at planning stage. You mentioned a very practical and interesting case where within the 100 days of our Uncle Trump, there came the tariffs and blah, 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 blah. How then do you work it in here? Your due diligence that your OEM, your external OEM would not be able to supply, not knowing what our Uncle Trump or anybody else, Zelensky or whoever comes up and do things that we did not expect them to do. how then do you work it in? Because your processes, which you would rely on experts and maybe you also just your knowledge, cannot preempt what happens globally. Thanks, Chair. Thanks, everybody.
Thanks, Carl. It's two interesting points there. Walter, do you want to pick those up before we go to
I
Gloria?
think let me jump onto them. Yeah. So that's why I say the second half of the presentation is where the heavier questions are coming. I'm happy that this aspect came about. So when you talk about the National Treasury restricted list or tender defaulters list, so that's the list where you put in those who have been deemed to have transgressed, and the accounting office of an organ of state has reported it to the National Treasury, and National Treasury then must inform that particular supplier that there is an intention to list them on this restricted list and give them, I think it's 14 days to respond. If they don't respond within 14 days, then obviously they automatically go onto the list. Or B, if they then respond, then it's up to the National Treasury then to make an assessment on whether or not what they've brought forward is sufficient for them to be listed, or B, is made sure that they're not listed, or C, that they send the matter back to the accounting officer for reconsideration. So it becomes what you call an administrative action. And I'm going to explain why I'm saying that. In the same way that, as you said, in your province, there's a similar aspect. And should you then be able to, for instance, maybe give an instruction note or give direction to other entities to say, yep, we've picked this up, please don't use this particular supply, and whether or not there's going to be a risk. So I can answer those together in that regard. So when you look at an administrative action, right, it means obviously, one, you're exercising a power, an administrative power that you've been given in terms of the law, and has got an external legal effect, as an example, on another party, right? And if that is the case, it becomes an administrative action and is susceptible to a PAJA review. And what does PAJA require on the base of it, without going into the technicalities? All PAJA wants is for due process. So PAJA doesn't even look at the merits of the case. PAJA is interested in due process. Has due process been followed? So in this particular matter with National Treasury, right, is that National Treasury skipped a step with regards to the set processing. So like it's a process, it's a written down process. So National Treasury skipped the part about giving the right of reply. Because I wanted to say audi alterum patem, but that's Latin, and I said no Latin today. The right of reply. So if someone says, hey, I'm listing you here and it's going to affect you from doing business and affect your constitutional right to economic activity, you must at least give me an opportunity to respond. I must not wake up in the morning and I've now been listed and now I'm being told I can't bid across the country. And I think it's a similar thing that CIPC is dealing with now when they de-register companies overnight, and now 1,000 companies or 2,000 companies are saying, but where is my notice in that regard? So here, when National Treasury was then confronted by the company saying, hey, why am I on this particular list? Right? They then realized that they had not followed due process, so they immediately removed them from the list. So it was not removing them from the list because, like, oh, actually, you're not guilty. It was because they realized that they didn't follow due process. Secondly, they realized that if they continue on this path, they may be taken to court on a PAJA review, and they will lose purely on not following due process in that regard. So that's how I want you to think about it, and how the aspect of National Treasury and how you would deal with it in your province as well, to say, make sure that in whatever you do, understand that whatever decision you take that has got a direct legal, external legal effect on another party, PAJA kicks in, because obviously you're an organ of state, and you must make sure that that due process is there and the other side is heard, and then a decision is made after that in that regard. The second part is the complexities that have come about by how the landscape has changed globally. Right. So, for instance, when you look at the tariffs, on day one, the tariffs were 20%, day two, they were 40%, day three, 60%, day four, they were back to 0%, day five, 125%. These are moving targets for you. Here you are trying to do due diligence. In that instance, you need to be honest and say, we can do as much as we can in terms of trying to predict, but it must not affect us going ahead with regards to the procurement process. But secondly, remember, some entities do they do currency hedging. I always say you must be very careful about currency hedging in a procurement process, because obviously you may peg a particular price on a particular US dollar to rand valuation, and then when the bidder wins, the currency has gone down and now you're paying a little bit more than you're supposed to do. So in that regard, you just need to then say, you know what, if I've got OEMs, as an example, that might be supplying our local supplier or directly dealing with them directly, is to make sure that there is constant communication amongst you and the bidders to make sure that all these fluctuations that are happening, for instance, will not have an effect. And if, for instance, the bidder says, you know what, this fluctuation is a bit too much, I won't be able to deliver, they must be given the opportunity to pull out themselves without you necessarily kicking them out in that regard. So that's how I would answer you in that regard. But yeah, we're in a very volatile global landscape, which is going to make planning stage due diligence very difficult.
Good one. I've got some questions as well. Let's go to Gloria. Thank you. I think Tsepo was next. Go ahead, Gloria. All right, let's jump to Tsepo.
All right, thanks, Sean, and thanks once again, Walter. Walter, I wanted to just comment on the advancements or developments that are currently happening in SCM, for example, in terms of mitigating non-compliance. I think because now Treasury, I want to comment Treasury on this regard, for the development of an e-submission, a system wherein most of non-compliance of whether you are restricted, whether you are tax non-compliance and whatever. So if you have to bid for a particular tender or quotation and you are going to submit via the e-submission, so all those, gray areas will definitely be out of, issues. So I will strongly comment that in actual fact, if I was treasurer, I would say it is a must of implementation because you are not even paying for it. So it serves as an electronic tender box, which is, interesting stuff. I mean, you're not worried about a non-compliance. But I also wanted to touch on what is your view on the establishment of a possible establishment of a public procurement institute? I heard you spoke about most people being on SIPs, for example, which guides in terms of how do you conduct your market research and all those other, environmental assessments, economic efficiency and all of that. But then what is the impact of that on, the foundation of SMME and EME establishment within the CIPC context? Because now, if you look at most of our EMEs and SMMEs, they are somehow, not to undermine to say uneducated, but there are people who are hustling to just want to make an income. And when you come to tell an EME about an environmental impact of, buying a pump that is solar powered or natural electrical powered, it's something else. And also we need to go back and ask ourselves, what was our founding pillars of public procurement? Why is it not just a procurement? Why is it a public procurement? What distinguish it to be a public procurement? Yeah, I think I'll stop there.
Good one. Thanks.
Yeah, thanks.
Thank you. Let's listen to Gloria quickly, then
Okay.
Walter.
Thank you, Sean. I'm sorry for delaying the first time. Thank you, Walter, for raising this issue, and also Sean for bringing this issue of due diligence. And I think it's a very, very important part of the process of procurement, because it brings, if one uses it correctly, it brings proactiveness in relation to deterrence of fraud and corruption. But it is so much ignored. I can tell you stories about doing due diligence proactively, even before you award a tender to anybody. So the pre-qualification level of due diligence, and I think is very, very important. You spoke about the cuts using technology, the computer-assisted techniques, the data analytics, which are very, very important to catch up with the culprits. I can tell you, in one organization I was working for, we were doing this at a pre-qualification. And what you find there, just quickly, without wasting time, some of the things, just one or two things.
Just one quickly, Gloria.
Okay, maybe one, where you find duplication of even the IDs of the owners or management, or you find duplication or the same company, the telephone numbers, and you find that these two companies have tendered. The other one is tendered at a lower price, the other one is tendered at a higher price. So there are those things. And when you do it, one thing we also forget is to look at the existence of that particular company. Like the other speaker has just said, that others are hustling. You'll find that there's no company at all. Those olden days, this type of due diligence was done. Lastly, I will combine these items in one. What is most important, and I think even from what you are saying, Walter, is to have processes or policies that defines when due diligence is done, what should be done, why it should be done, by who and how. So if our due diligence policies answers those, and I think it will help. Linking that to the issue you raised about the resources and the time taken to do this due diligence, one of the challenges is that our plans, the tender process, is not linked to the procurement plans that we have. Because if you have your procurement plans in your APP, you know when you are going to deliver something, because procurement is linked to service delivery and achievement of goals. So there should be a direct link. So you will cover this issue of lack of time and resourcing to do due diligence.
Thank you.
Lastly, very important thing, in your structures, you have forgotten the internal audit. And internal audit is key on this, even at the beginning of the procurement process. And that's basically what I wanted to also allude to. Thank you.
Good. I'm keen to hear from Mandy, but go ahead first, Walter, on those 2 points.
Yeah, no, thanks. Thanks. I like the part about, an institute that not only is there for procurement practitioners, but also for businesses, specifically your small businesses. And as I said, I wear many hats. I don't know why. So there's an initiative that was started last year, and I was fortunate enough to be called to assist with it, run by BUSA, which is the Business Unit South Africa, the National Business Initiative, because they focus on small businesses, and also GIZ and SAICA. So what we did is we called small businesses and said, come and get compliance training, come and get risk management training, all these aspects that affect you as a business, A, internally, but two, externally, and how you engage external parties when you bid for these things. And I think what I'll do, Sean, is I'll try and see if I can link you up with the ethical supplier initiative that just started this month, because it will speak to that question about making sure that both organs of state, public procurement practitioners, businesses are all in one page in how to deal with public procurement, compliance, and the commercial aspects in that regard. And obviously, the last thing is procurement plans have always been something that I've always preached about, because once you've got a procurement plan, half the problems you have go out the window. But I think we can go to the next one. Yeah.
Good one. Mandy, do you want to go ahead?
Hi, everybody. Am I audible?
Yes, you are.
Yes.
Okay. So firstly, I want to say thank you for your presentation, and you hitting the nail very much to a T on this. Is that I'm a procurement analyst and I assist municipalities in developing procurement plans, and we look at due diligence very much in this, because we have found that companies don't disclose everything. So we have to go around to see other areas. So, for example, we had fronting happening where companies are using their trusts, but they don't declare they say the trust owns 100% BE, or they are meeting the codes. And then we also have, then they circumvent around that the trust gets 100%. And then we have companies that sworn affidavits aren't consistent, where the court actually recently, the Western Cape High Court actually found in October 2024 that one of the companies, because of the sworn affidavit not utilizing the latest financial statements, they were found that the municipality had to re-advertise the process because of that. But that's a thing of not following due diligence, because the only thing, when valuation occurs, we only look at, oh, there's a BE certificate or there's a sworn affidavit, and we don't go into further details of who's owners, who's are the beneficiaries, and is it that we are authentic to our what we are declaring, and the declarations that are made, is it really true declarations? And that's why I'm very much happy for the Public Procurement Act that has technology to be utilized in this instance. But currently with CIPC, that isn't integrated into the e-procurement system or the e-port CSD, is making it difficult to verify what is on CIPC if you don't have license. And this is where we started finding out that ownership and membership and directors that are disclosed on CIPC is not the true reflection of what is reported on the CSD. These are because we have followed due diligence, and we've advised organs of states on this, but some organs of states are still reluctant, even sometimes, to say, okay, we're going to withdraw this tender, we're going to call them in, we're going to do the ultra patra rule on this and see what went wrong on it, give the person the benefit of the doubt. And this is what is causing the other mayhems of projects being delayed and organs of state paying premium, and even except the organs of state, but also the companies paying premium on it because there's delay, and then obviously price increased on certain materials, goods, and things. As we know, the CPI influence a lot of things, and prices that was yesterday is not of today.
Thanks, Mandy. Mandy, I'm going to have just going to have to cut you off there. Sorry, Walter has got just these 2 hours, and he's going to need to leave us shortly. So
okay, no, I understand.
Good points. Thank you.
But thank you for your presentation on it.
Thank you. Very good. Walter, some closing comments, and then we can wrap up. Thank you very much.
Yeah, no, thanks. Thanks. Yeah. So what I'm picking up here is that obviously there is an appetite for due diligence,
Yeah.
but obviously we need to make sure that we give the necessary support to procurement practitioners on how to set up those processes. And perhaps I should stop coming once a year so that at least we can have more of these discussions. But I think let's always try and make sure that we go through some of these cases. If you don't know how to read cases, it's fine. We can always assist with some of the summaries and pick up some of these principles that are quite critical. But the last shot is that let's make those bold decisions.
Good one, Walter. Good. And thank you very much. Thank you for your time. Thank you for all the preparation that you put in. Would love to engage some more on what you've got there. I see Charles still keen to engage, but
bring Walter back for those administrative case laws. Please, he can't run away from it. We want to know if those admin cases were wrong in terms of SEM. He can't run away from it. No, he needs to come back. Thank you.
Good one, Charles.
Thanks, Walter.
Okay, will do, man. Thanks.
Thanks very much, Walter. Good one. Thanks, everybody. We're going to have another court case next week. And yeah, so we'll certainly send that out. Thank you, everybody. And thanks for joining us. And happy birthday again, Mr. Mabete. All the best to all of you. Thank you. See you next week.
You're very kind,
Thanks,
Mr. Scott. Thank you very much indeed.
Thank you.
Thanks,
Bye.
Walter. Well done.
Bye.
Bye, everyone.
Bye-bye.
Hi. Thank you.
Octavius, thank you.
Thank you, Sean.
Thank you.